Hello, everybody, and welcome to this third and final session of the second round of our Open Access 101 series. My name is Nick Shockey. I'm Spark's Associate Executive Director, and am also really excited about today's OA 101 session. With the effective date of agencies' public access policies in the U.S. Rapidly approaching the Nelson memo deadline at the end of the year again here in the States. I know that authors' rights and supporting faculty as they navigate those funder policies, and publication agreements as well, is top of mind for so many folks. And even more broadly and beyond the US, as we heard last week during our Spark event on open access, AI, and attribution, authors' rights is also a central issue as faculty navigate the use of their work by large language models and make decisions about whether to sign over their copyright or license their work under open licenses that can actually provide stronger protections around things like attribution. And I'd say, for Spark, authors' rights holds a special place in our hearts as well, having been a central theme and one of the longest standing areas of Spark's work, dating all the way back to the trusty old Spark Authors Addendum that's been around for quite some time at this point. And so for today's conversation, we are thrilled to once again have Dave Hansen, the Executive Director of Authors Alliance, joining us for this conversation. We hope that today's session, like the others in the series, will be helpful, lightweight professional development for folks working in different types of areas across libraries. And to that end, I also want to give a short plug to our just announced Open Education 101 series that just went out yesterday. And I've just popped a link to that announcement in the chat, and hope that if that's relevant for your work, that you'll consider joining for any of those sessions or pass that announcement along to any colleagues, at your institution or elsewhere that might find those sessions useful. As with all the other sessions in the series, would strongly encourage folks to introduce yourself briefly in the chat, and also encourage folks to stay active in the chat throughout the session, to comment, to share your own sort of relevant experiences related to areas that we touch on with Dave's presentation or in the Q&A afterwards. And again, even just reactions can be great. I've definitely found that increasingly with some of these Spark sessions, that the reactions can help recreate a bit the feeling of being in person together in the more sterile virtual environment. For questions, though, we would ask that you use the Q&A functionality on Zoom that will help us triage those questions and sort of better allow us to sort of catch those rather than potentially missing them in the fire hose of chat, mark things as answered and so forth. So do use the Q&A for questions, and you can also ask things anonymously or make comments anonymously through the Q&A if that is more comfortable, and also upvote or comment on others' questions there. We are recording today's session, so just want folks to be aware of that, particularly if you come off mute to ask a question during the Q&A. And then finally, with this being the last entry in our second round of the Open Access 101 series, want to touch on two things here in closing. One is just to reiterate how incredibly fortunate we at Spark are to have such wonderful collaborators in Josh Bullock, Maria Bond, and Will Cross in organizing the events. We have benefited tremendously from their knowledge, their expertise, and more broadly, their approach to just supporting the people doing ScholComm work within libraries. And they're also just a lot of fun to work with. So really, really appreciate all that you all have poured into this series, Josh, Maria, and Will. We really couldn't have done it without y'all, and always really enjoy collaborating with you on this. And then the second thing I want to plug here in the last session of this round is just to again encourage folks to take 30 or 60 seconds after the webcast to provide feedback through the brief survey that will automatically load at the end of the session. Today's survey will help us to gauge where to take this series in the future and also what other types of lightweight professional development opportunities are most useful for folks. And we really can't do that without your input. So many thanks in advance for just taking the extra few seconds to fill that in. It really is incredibly helpful for us. Finally, with that, I will go ahead and turn it over to Will Cross to help open today's session and introduce our speaker, Dave Hansen. Will, over to you.
Thank you, Nick, for that very, very kind introduction. Thanks to Spark for hosting this event. Thanks to everybody who's here live. And if you're checking in on the recording later on, thanks for doing one of the hardest and rarest things in the Academy, actually going back to watch all those recorded versions that we all have on our devices. I'm delighted to have Dave here today to talk about the role of copyright and open access. Smarter people than me, probably including Dave, have noted that one of the greatest ironies, maybe even in a sense the inciting incident of open access, is this broad adoption of the internet at the same moment that copyright became automatic. And this led to this formalization of a scholarly communications ecosystem that had relied heavily on informal, often uncopyrighted uses, lab notes, lecture prompts, comments on a friend's draft, and that sort of thing. And as we've seen over the past sessions, it's radically transformed what had been financially somewhat a low stakes publishing and sharing system into one that is now very commercial and very, very high stakes in a lot of different ways. One of the great casualties of this change is the core idea of authorship, which copyright law often boils down to ownership in a way that flattens a lot of influences, contributions, and a ton of invisible labor from colleagues, from librarians, and many, many precarious workers in the system. In a field where we talk a lot about authors' rights, as Nick said, the question, who is the author, matters a lot. And as AI pushes these questions into sharper focus, it matters, I'd say, even more today. The good news is we couldn't ask for a better guide through these issues. Dave is executive director of the Authors Alliance, which works to advance the interest of authors who want to serve the public good by sharing their creations broadly. Dave has worked in libraries for many years, including as an AUL at Duke, focused on collections and copyright, among other things. Dave has testified before Congress, the U.S. Copyright Office, and the USPTO on a lot of these different issues as well. And just today, I would be remiss if I didn't say Dave has introduced his new podcast on the intersection of technology, culture, and information policy. I've dropped a link in there. I've listened to the first episode and it's great, and I know the rest will be as well. So that's probably more than you were expecting or hoping to hear from me. So I'm going to hush up now and pass the baton over to Dave. I'm so excited for this session on this big, big question in OA: who owns scholarly work?
Thanks, Will. And thanks, Nick. And thanks for everybody who organized this. I'm going to turn on some slides here. There, and you should be able to see them now. And I'm joining from just outside Chapel Hill, North Carolina. So I saw everybody putting that in the chat, and it's nice to see people joining from all over. So I'm really excited to be here today. And I'm not just saying that because that's the thing people say at the beginning of these kinds of events. I think that this whole series is really fantastic. And on this issue in particular, I was excited to be able to share. I actually have something to say here. Sometimes I get invited to things and I'm like, gee, I don't know if I have a point. But I think this is a real live issue that libraries are grappling with today and universities are grappling with today. Is how do you navigate this kind of tension between openly sharing and then having concerns about, like, are we, kind of feeding the tech oligarchs? Are we kind of feeding into technology that maybe we have some misgivings about? And I think it's really important. I also think it's an issue that libraries have a real opportunity on their campuses to show some thought leadership, I think, and some leadership in other ways in terms of facilitating a really good environment for helping authors understand the rights that they have, and how that relates to this bigger system that they are a part of, both in scholarly publishing and information policy more generally. So I'm going to talk about who owns academic work with a specific focus on how that relates to open access and artificial intelligence. And I thought if you're the kind of person who's showing up for a Spark webinar on a Wednesday afternoon, I probably don't have to convince you a whole lot about open access being like an important thing, or a phenomenon that we ought to be paying attention to. So I wanted to spend most of my time trying to help you come out of this webinar with the ability to talk cogently about how issues of open access and ownership of scholarly work fits together with an environment where we see lots of copyrighted materials all over the web being scraped up and used as training data for artificial intelligence. Is that a good thing? Is that a bad thing? Is that something that we can even do anything about? Those are some important questions that I think we want to work through. Um, and so one goal that I have is I'd really like to help you understand the underlying copyright situation and the licensing situation for academic works, maybe a little more clearly. And in particular, in the context of institutional open access policies, and federal funded research, public access policies like the NIH policy that Nick mentioned that is going to be effective in just a few weeks here. Um, and then the last goal I have really is to help you come away with some ideas and just talking points when you encounter authors on your campus to help them sort of think about these issues a little bit more deeply. Um, so Will gave a nice introduction to Authors Alliance, but I just put a slide up here in case you haven't heard of us. Our mission is to advance the interests of authors who want to serve the public good. And we were founded about 10 years ago in the middle of the Google Books lawsuit, which you might remember. That was a very big copyright lawsuit with a lot of parallels, actually, to what we see happening today in some of the AI copyright lawsuits. And in that suit, there was a group of authors who said, we think that Google scanning books and allowing for search and find functions and for text and data mining applications, we think that those things are all illegal and they shouldn't be able to do that. And in addition, we claim to represent all of the authors who might have an interest here. And so Authors Alliance didn't exist at the time, but there were a lot of authors who said, gee, we don't agree with that. We actually think that being able to assemble a large corpus of text and conduct research on it is a pretty good thing. And assembling a large corpus so we can do text searching and things like that is also really good. And so that group of authors got together, filed some briefs in those cases to help persuade the court that there are other points of view that ought to be taken into account here. And then out of that really came Authors Alliance. So we do lots of things on open access. We have a really great partnership that we've had for this last year with Spark on a series around legal issues with open access. It's called Legal Pathways to Open Access. We've put out a couple papers on that, on various aspects of federal public access policies and their legality. So I just wanted to give you a little intro to who we are, and our point of view. You can check out our website. We have a lot of free resources. We put out guides on legal issues like how to think about your publishing contract or fair use, and they're all openly licensed under CC BY licenses. Yeah, I also invite you to join as a member if you're an author, or we also have a partner program for academic libraries. So let's get into this. So the premise, the question here is who owns academic work? And as a lawyer, the lawyer in me always cringes when people use the word own. I don't know how many lawyers are on the call today, but I could give you a little kind of mini nightmare in the middle of the day here by forcing you back into your first year property class, where you talk about ownership of property. And you start to realize that the word own doesn't have a whole lot of meaning. You start to split that apart and it gets atomized into these kind of bundle of rights that people have. That's often how lawyers talk about ownership. And in property class, you're often talking about like, what does it mean to own a piece of real property, a house on a piece of land, and what sort of rights do you get with that? And I think that it's helpful to break this down a little bit, not to get too philosophical about what ownership means, but a lot of times we just sort of gloss over this word and assume that we're all on the same page. So these are just some basic definitions. I particularly like the last one, although I don't think that's what we're really focused on here. But really, what we're talking about is who has power over a particular article, a particular intellectual output. Of course, when we're talking about a research article, there is a physical instantiation, presumably somewhere. Someone printed it out on a printer, I bet, at some point in its life. But we're not really talking about control of that physical object. We're talking about power over certain legal rights that attach to that article. And so, what I want to talk through is where do these legal rights come from? Um, and what are the different legal arrangements that allocate control over those rights, essentially? Um, and we really want to back off of that a little bit and think not just who owns these rights, who controls these rights, what exactly are they trying to do with them? Um, and so I think we want to back up a little bit even more and say, well, what is it that authors want? What is the power that they want here? Um, is it to control reproduction and distribution of their work? That's what the Copyright Act would say, right? The Copyright Act grants authors the right to control reproduction and distribution of copyrighted works. But for most people, that's not an end in itself. Like, I don't get a whole lot of value in saying, you can make a copy of a thing that I wrote. No, what I want with that is to use those rights as a means to an end. And the Copyright Act has a sort of version, it has a sort of user story that it presumes. Um, and that user story is it presumes that people want to control reproduction and distribution of their work so that they can leverage those rights for compensation, right? So they can say, I will only let you obtain a copy of my work if you pay me directly for it. That's kind of the user story that the Copyright Act presumes. But we know that academic authors kind of work differently. Um, Academic authors, for the most part, are supported financially in other ways. They're faculty members, they're grad students, they're postdocs. Um, and in any case, the kind of transaction that happens for an individual reader of an article would be very, very minimal. And so, for the most part, what we find is that academic authors have some other goals. Um, they would like to get people to read their work. They certainly would like people to cite them. They sometimes want to prevent reuses that they don't approve of, although that starts to get pretty squishy. Oftentimes, when I talk with authors about what these reuses are that they don't approve of, it's very hard to nail that down. Um, Occasionally, academic authors, will think that they're going to make money off of their works. Sometimes they do, most of the time they don't. And then we have some other sort of ideological goals here that I sometimes see surfaced from authors. Some of them really hate big tech companies. Some of them just really hate people who run big tech companies. I've heard more people tell me that they don't want Elon Musk or Mark Zuckerberg to use their work than I ever thought I would hear. Um, and so sometimes there's an ideological or a personal kind of goal. Sometimes it's against the publishers. I've heard a lot of that too. You all might remember several years ago the cost of knowledge protest against Elsevier, and there was a large movement to say, as authors who have some power with respect to our works, we object to the way that you are treating us and treating our objectives with our work. So, again, not to be too philosophical, but I think it's helpful to kind of back up a little bit before we just run headlong into the law to refocus a little bit on like what is it that authors are trying to achieve here? Because I think if you do that, it becomes a little bit easier to understand the dynamics of what's happening in the legal and contractual environment. So this is my thesis of this whole talk. This is my main point. Um, Open access is a countermeasure to power consolidation. And I think that this is true. This has been true for the last 2 decades. It has not been a perfect countermeasure by any means, but it is a really important one to prevent power consolidation. And one of the things that I want to talk through with the legal environment is how that's sort of shaded by the realities, the market realities, and the negotiating position that authors often find themselves in. And in my mind, at least, one of the most important things for authors to think about is how to prevent their work from being co-opted by others who have more power in this system. Um, so point number one, um, authors rarely have full control over their work. So this sort of, you might be surprised to hear this from like the guy from Authors Alliance, who you'd think I would stand up and say, authors, have and should retain all rights in their work. And this is the most important thing. Uh, Actually, the reality is authors rarely have full control over their work. So in most jurisdictions, and I'll kind of walk you through this, in most jurisdictions, authors are the initial copyright holders. So we got that. That's a fact. Um, but for the most part, especially for academic works, we immediately have strings that are attached to those works. And you can see those strings in a number of different places. University IP policies, university open access policies, funder policies. In some nations, there are actually carve-outs and things like that. And then, of course, the string that we are probably most familiar with is the string that attaches to publishers' contracts, where the publishers say, yes, I will publish your paper, but I have some conditions on that. And often that includes a substantial string attached to the underlying copyright of the article. So I know this is a 101 series, but I want to talk you through Copyright Law 201. In particular, Title 17 of the United States Code, which is the Copyright Act, Section 201. So these are three different pieces of U.S. copyright law that are relevant for this discussion. So the first piece is, I think, the most intuitive. It says copyright in a work is protected in and invests initially in the author or authors of the work. That's like what we all expect, that authors are the initial copyright holders. But the law gets a little more complicated than that. And one of the ways that it gets more complicated is that it provides this kind of fiction for who the author is in certain circumstances where you are an employee. And this is an interesting provision in that it's not universal. So if you look at jurisdictions across the world, not every place has this work made for hire doctrine. But it's really important in the United States, and it really does have a really meaningful effect on the role of a university and the role of federal funders in dictating the availability or not of an author's work. So this provision says that in the case of a work made for hire, the employer or other person for whom the work was prepared is considered the author for purposes of this title, unless the parties have expressly agreed otherwise. And so it's that person that owns all of the copyright. And so this is a really important term. We have to figure out here that if I work for somebody what's the arrangement between them? And is my work going to be considered work for hire? So that's point number one. We'll get into that in a moment. And then the third thing here is about transfer of ownership. And again, this is pretty intuitive. We know that if we sign an agreement, we can transfer our copyright to others. But this puts some conditions on that. It says that ownership of a copyright can be transferred in whole or in part by any means of conveyance or by operation of law, and may be bequeathed by will and all these other ways. And then it gives us a little limitation on that, and it says, but if it's an exclusive right, then it may be transferred. And the owner of that exclusive right is entitled to all of the protections afforded to the copyright owner under this title. Effectively, they get treated the same. So this is a really important thing because authors are often asked to sign these agreements to transfer their rights. So is it a bad thing that we have strings attached? Not always. And that may sound like a funny thing. But no, I actually think this is not a bad thing that authors sometimes have strings attached to their works. But sometimes it definitely is. These are just a couple of examples. I could go through the Authors Alliance blog and like pick out maybe one one every month or so of like some bad thing that happened because authors uh, were persuaded to give away their rights. So the first one here was a situation where Wiley removed some 1,300 ebooks from academic library collections. They did it in, I think it was like August 1st or something like that, just before the academic semester was going to start. People had already kind of said, we're going to assign these books. They were in collections, and then they just sort of were going to be disappeared. Whoops. And they never told the authors about this. And in fact, when you looked at the authors' contracts, they probably didn't have to. Uh, Yet, a bunch of us got together, a bunch of academic authors, and one thing Authors Alliance did is we just wrote to all these authors and said, "Did you know that this is happening to your work?" And many of them were just aghast at this. And so, that's not great when your publisher doesn't act in the way that you expect them to, even though you've granted these rights kind of in good faith and expect them to be a good faith dealer. Um, Sometimes this happens in other ways, like the bottom example here. There's a situation where if you sign a certain type of open access publishing agreement with Elsevier or Wiley, particularly one where you're licensing your work under a CC BY non-commercial license, one of the interesting facets of the Elsevier and Wiley agreements there is you may think that you are restricting commercial use of your work when you do that. But in fact, if you really read the details of that agreement, what you're doing is you are restricting commercial use under a CC license, but you are at the same time granting Elsevier or Wiley, respectively, the exclusive right to profit off of your article. So it's kind of very different from what I think most authors expect when they sign a CC BY and C license. So sometimes things don't happen the way that you would hope with these sort of strings that get attached to your work. But there are some reasons why you might want to. One, and I think this is probably the most significant, is that authors sometimes sign away their rights as an acknowledgement of their bargaining position, trying to get others to act on their behalf. This is really how I've come to look at university open access policies, is authors conceding that as an individual author, they don't have a whole lot of negotiating power when it comes to their articles. But if they can get their institution behind them, in a way that kind of collects those rights and makes it difficult for publishers to pull them away, then that really enhances their bargaining position. Um, and so when interests are aligned, authors have been really happy. And in fact, a lot of university open access policies are faculty driven, where the faculty get together and they say, yes, this is what we want. We want to grant this right to the university because then the university can act on our behalf and we can't be sort of bullied out of these rights that we have. We see some similar dynamics emerging with funders. The relationship is a little different, right? Faculty don't get a vote with funders, but for the most part, we've seen that funders have looked at those open access policies and said, we have some of the same objectives, and why don't we create similar policies? So what does this mean for artificial intelligence? A few things. One is we have seen that authors regularly just sign over all of their rights to publishers, especially for academic book contracts. Um, this is a real issue where authors are just asked to like sign wholesale their rights over to publishers. They hold those rights and they're able to basically do what they want with them. And so we've started to see some activity where these articles are being used in ways that authors maybe didn't expect. These are just some of the examples. We've heard Wiley doing these deals, Sage, a number of others. Some publishers are asking authors what they think. I did a really nice, I had a really nice talk with Ben Den at Cambridge University Press, I think, director of academic publishing, and they've done an effort to reach out to all of their authors, tens of thousands of authors, and ask them, "Would you opt in to allow us to relicense your work for AI purposes?" The University of Michigan has done something where they've reached out to authors for similar purposes. MIT Press has done something similar. And I think those are nice. And really a good way to gauge author interest, uh, and to get a sense of whether authors' views are aligned with the press on downstream AI licensing. A little like caveat to put there, one concern I have with those efforts is that they may misrepresent inadvertently misrepresent to authors the ability of the publisher to actively and effectively control what AI companies are doing with their material, anyways. So I'll get into that in a little bit. It may depend on what the AI company is doing with it. There's a big difference between, for example, training a model on a certain set of material and producing a system that, a like retrieval augmented generation system that's actually reproducing chunks of text and directing users to underlying content. Those, from a legal perspective, have probably a pretty different permissions requirement. Um, so, uh, So this actually gets us back to this question of our academic works work for hire? So I want to kind of take us on a little journey back there because this is actually an important issue for figuring out who owns rights initially and who gets to control them. So remember, I started off, I said authors are the initial owners of works, but there's this provision of the Copyright Act that says that if you work for somebody, maybe the work that you create is owned by them and they have the right to dictate what is done with it. This is a hotly contested issue. I have a one book that I think is really good on this. It's older, but it's still definitely relevant. Uh, is this book by Corinne McSherry about who owns academic work? And it kind of goes through some of the case law and some of the other history around ownership of academic work. Uh, and the short version of this is that who under the Copyright Act owns academic work is very hotly contested. But as it turns out, this may not be as important of an issue as we think. And I'll try to talk you through why I think that is so. Um, so we have two things that are going on here. One is under the Copyright Act, we have this definition of work for hire. Um, and work for hire is defined in the law. And it's also defined by the Supreme Court. The Supreme Court in a case called CCNV versus Reed, which dealt with like an independent contractor situation, someone creating a kind of custom-made sculpture. There was this question about who owned rights in that work. And what the court did is they went and they looked at kind of traditional law of agency to determine whether this person was really acting on behalf of the employer or whether they were acting kind of on their own initiative. And so these are some of the factors that the courts look at when determining whether that is the case. And if you look at these and you think about what academics do, what their job is, like if you looked at a job description of a faculty member at your institution, what it would say, it would probably have something about scholarship, right? About writing, about that being a requirement of the job. The university supports that in various ways by providing space, by providing research tools, by providing a computer, essentially the tools necessary to create. Um, and so when you start going through that kind of analysis for faculty, it starts to look like they would fit pretty cleanly under what's known as this work for hire doctrine, and that their works should be treated, at least just with nothing else at play, as a work for hire. Where this gets really complicated is that copyright law has a history with academic works, stretching back over about the last century, and particularly under the previous Copyright Act, the 1909 Copyright Act, we had something emerge in the case law called the teacher exception. Um, and where exactly this came from remains a little bit of a mystery, but the thought behind the teacher exception is that teachers are kind of different. Um, and there are lots of reasons why we might want to have or give academics, to give teachers a little bit more freedom in what they create. So, for instance, no one, I think, would agree with the idea that a university gets to dictate precisely what a researcher writes in their article, right? They don't get to say what is orthodox and what is not allowed. The university doesn't kind of hover over your shoulder and tell you precisely how you're supposed to write your paper or how you're supposed to express yourself. We have principles of academic freedom that say that that's a really bad idea, and that, academics writing and engaged in scholarship need a certain amount of freedom to go out and write things on their own. And so that's part of the basis of this idea of a teacher exception. Um, where this gets a little squishy is that most of the relevant cases were decided under a previous law that did not have such a clearly defined work for hire doctrine, um, and were decided prior to this CCNV versus Reed case. And so there's a real question about whether this teacher exception continues to apply. Um, and that sounds like it could be a pretty big deal because basically that dictates who is the owner of the article. Is it the university as the employer, or is it the faculty member? Um, so for the most part, there's a few different ways that university IP policies have dealt with this. And I want to focus us. I see in the chat someone mentioned institutional policies. That's where really a lot of the decision making happens here. And this is part of the reason why I say the work for hire doctrine may be not the most relevant thing for determining ownership, because we know, if we go back to the beginning, that regardless of who the initial owner is, you're allowed to freely transfer those rights through a written agreement. And that is a very, very easy thing to do. And that's one of the things that these university policies can do, is sort of paper over in a way that work for hire question, if they do it smartly. So this is one version, and Yale University kind of takes an interesting point of view. They just state their position on copyright law. They say that a work created by a person in the course of his or her employment belongs to the employer. They are full-fledged on the work for hire doctrine. But that doesn't mean that they're trying to control everything that comes out of their faculty and grad students and postdocs and so on. They take the position, as practically every university that I'm aware of does, in some way or other, that for traditional works of scholarship, for things like books, articles, other scholarly writings that are by a faculty member, they're deemed to be the property of the writer. So basically, what the university is doing here is saying, we may have rights to this, but we're handing this back to the author, back to the writer. And that's a pretty typical way of dealing with this issue. Here's another example. Ohio State, I think, has a very precise policy. I like their policy because they define all of their terms. All these bolded terms here have specific definitions at the beginning. Um, and so one of the things that this policy does is it identifies, it says all copyright and instructional works, scholarly works, artistic works, whose creators are faculty members, except for software. There's a carve out for software. There's often also a carve out for instructional materials, by the way. They remain with their creators. And it says the university hereby assigns any of its copyrights in such works insofar as they exist to their creators. So that's really important. So they take kind of the same view, or they try to achieve the same result as Yale without being quite as clear about what they believe about the work for hire doctrine. But there's one little thing in here that I want to point out that's really important. It says subject to the terms of Section 6. So you got to read these things really closely. And Section 6 is going to be a really interesting part of this policy. And this is where we have to really think about the relationship between like funders and universities and authors and how all that relates to open access. So I just want to flag that. Here's one that I'm really familiar with. Duke's policy. I used to work at Duke, and I've spent a lot of time thinking about this policy. Duke has a really different approach. They just sort of broadly describe what they believe to exist, and take this statement as like truth. And don't really try to define terms. They just kind of leave this open and say, yeah, we follow the traditional rule. We reaffirm I think it's interesting that it says reaffirm because I don't know that it affirmed elsewhere before this, but reaffirms the traditional commitment to personal ownership of intellectual property rights in works of the intellect by their creators, whether they worked alone or in others or with other people at Duke. Uh, and Duke applies this to everyone, really. They don't apply it just to faculty either. They say it applies to all faculty, staff, and other people receiving compensation. So it covers all employees. Um, so that's another kind of approach. But they all try to basically achieve the same thing of saying for scholarship, the university is not trying to like do a land grab here and capture all of these rights. Um, we also have a set of other policies that gets layered on top that maybe does give some rights back to the university. And this happens in a couple of different ways. I mentioned faculty open access policies already. Here's one example, the Harvard model. This is the Harvard Faculty of Arts and Science open access policy. And the highlighted portion here is kind of the punchline. Each faculty member grants to the presidents and fellows of Harvard College permission to make available his or her scholarly articles and exercise copyright in those articles. This is a non-exclusive, irrevocable, paid-up worldwide license. There are meanings to all those things that I won't go through right now. But basically, this is saying we're granting a license to the work that the faculty have. They're granting that back to the university for this specific purpose of making their articles available openly. So that's important. But one of the things that is also important is how this all fits together with grant requirements. So one of the things that the NIH, we were aware of the NIH accelerating its public access policy. There are a number of other federal agencies that are doing this, that are implementing their policies over the next several months, year. And one of the questions is like, how do they get the necessary license, the necessary rights in these articles to then share them through the public access repository? Well, the answer is that these agencies have for a very long time actually held this right. This is a provision that is part of the grant standards, the like standard terms and conditions that you agree to when you get a federal grant. And it says that grant recipients may copyright their works, but the federal agency reserves a royalty-free, non-exclusive, irrevocable right to reproduce, publish, and otherwise use that work, and that includes making it available through agency-designated public access repositories. It's like pretty clear that they have a license to do this. One of the important points here is how does that then connect to university IP policies that in general hand back rights to the faculty that say, regardless of work for hire or whatever, we believe that faculty should hold these rights. And the answer is in these little carve outs, like what you see here for Ohio State, that says subject to the terms of Section 6. And if you went to Section 6, I should have put it in my slide here, but if you went to Section 6, it predictably has a term that says nothing in this university IP policy will restrict the ability of the university to comply with the grant terms that we agree to. And so, in effect, what it's doing is saying we're going to grant back rights to the authors, but only insofar as that doesn't limit our ability to comply with our grant terms. And that's pretty common across university IP policies. So that's kind of the chain of title there that allows for those federal open access policies to be effective. All right. So I think that's enough about sort of the chain of copyright title. That can get a little dry, but it's important to be able to trace those pieces together and understand who actually has the power to authorize reuse. And in a lot of cases, the main takeaway there is in a lot of cases, that's determined by university policy. And in most cases, those university policies are mandatory. It's like if you want to work at this university, you sign your name at the bottom of the employee handbook that says, I agree to these policies. And that's how that happens. So back to AI, I want to talk about how handing over exclusive rights can be kind of unfortunate for particularly academic artificial intelligence applications and text data mining applications. So what I have here is a story. This was posted in Retraction Watch some time ago about a paper that looked at news reporting on vaccine hesitancy. And this paper did a pretty robust study trying to understand how people are talking about vaccines and what kind of hesitancy they have with different vaccines. This came out in the midst of the COVID pandemic. Um, and so they did this text data mining project where they grabbed a bunch of papers or a bunch of newspaper articles and did some textual analysis across these. It wasn't like groundbreaking from a technological standpoint, but it was, sophisticated and it was legit text data mining research. Um, well, this paper got published, and then a very unfortunate thing happened. Um, Someone started looking at this paper and figured out that the researchers were coming from institutions that did not have licenses that permitted them to engage in text data mining on the subject works. I think these were from Factiva. Uh, don't quote me on that, but it was one of those types of databases. Um, and so the authors didn't have permission, and they didn't have a clear pathway to explain their legal case for why they should be able to do this. And so the end result was that this paper got retracted. And I think it was very unfortunate because it was retracted not because the science was bad, not because the results were inaccurate, but because they didn't have someone who gave them permission to do this on based on intellectual property rights, licensing rights in newspaper articles. Um, so this is a real challenge, I think, for AI use. And we're starting to see academics get other license restrictions imposed on them for engaging in this kind of use. And you might be thinking, how come you're talking about academic AI use rather than, ChatGPT or these other types of services? Well, I think that we've all heard of those, but I think academic AI use is really important to focus in on because there's an awful lot happening here on a lot of campuses where people are trying to use these tools in the course of their research, and they need access to copyrighted works to do that. And including they need access to scholarly works that they may want to analyze or summarize or use to, fine tune a model or train some custom tool. And so one of the challenges that we see is that we are now seeing license restrictions being imposed on users of licensed databases. So this is an example of a license restriction. This was actually shared with me by someone from the University of California, where a vendor, a publisher came in and said, we need to amend our agreement because we are concerned about people using content from our data set, from our database, in conjunction with AI tools. And so this is what they proposed. Uh, or this is actually a negotiated version. The first version, as I understand it, was, and other people's first versions of this were very, very restrictive and very challenging to work with. And so, this says that users can't directly or indirectly develop, train, program, improve, or enrich any AI tool, or reproduce or distribute content from this database to any third-party AI tool. The part that has been negotiated a bit was the accept. And this is one pathway that universities, including University of California, have been successful in kind of finding a way to insert an accept to allow academic users to engage in some of these uses in sort of restricted, safe environments. But this can pose a real challenge. So one of the things, one of my favorite people to work with is Rachel Sandberg at the University of California, Berkeley. And we've been talking about this for a while. And she had this great idea of just like spelunking through the literature um, and doing this research kind of across the years to look at what are the kinds of studies that people have done using text data mining techniques, using AI tools to better understand scholarly literature. This is just one example. We talk about, or she talks about this in a blog post that we put together on the Authors Alliance blog, about what would happen if we had these flat out restrictions on use of copyrighted content with AI tools. Um, and so I just flagged this. This is an interesting one. You can check it out on our site. We have a description of it. But basically, it talks about a whole series of research applications that could not happen if those license restrictions that we had earlier were in place. Um, so, there are a couple other things in addition to license restrictions on situations where the author has handed copyright totally over to the publisher gets a couple of things that they can do with that. One is restrict academic use. The other, as you've seen earlier, is to relicense those things out and engage in contracts with commercial AI providers. The other thing that is kind of challenging in this space is that even for open access articles, where authors seek to have their works widely disseminated and widely reused, there are some emerging challenges. So, for example, in the EU, they've adopted a framework that says that if a rights holder opts out using machine readable opt outs, then their work can't be used for any sort of AI applications. And so, this is just something to flag here, a little bit of an aside, but even for your open access articles, if they're residing on a website that includes a broad opt out, that could mean that your open access article that you want to be widely disseminated, widely reused, ingested into these systems for a variety of purposes may not be. So this is just one example of an article licensed under a CC BY article. But if you scroll to the bottom, you see that there's this real restrictive text that says all rights reserved, including rights for text and data mining, which is definitely more restrictive than what a CC license would allow for. And speaking of CC licenses, that raises a real interesting question of does a CC license really encourage or allow for uh, more AI use of your work? From a strictly legal perspective, I don't know that it actually does. Creative Commons issued this short statement recently explaining that actually a lot of this is permitted by law anyways, or we think it is under fair use or other national limitations and exceptions. And so that means that if those apply, you don't actually have to follow the Creative Commons license restrictions. Um, and so that can be a surprise to a lot of people. I think a lot of authors that I've encountered have looked at Creative Commons licenses and said, I'm down with this open access Creative Commons stuff, but I don't like these big AI companies using my stuff, so I'm going to apply a non-commercial license. Well, the reality is they might not need to comply with it anyways if fair use applies, which it looks like it likely does in a lot of cases. So the counterfactual is kind of an interesting thing to think about, and I'll close with this. Um, the counterfactual of saying that uh, users of copyrighted material for AI training, for text and data mining, whether commercial or not, can proceed with that under fair use or without getting permission is that counterfactual is pretty bleak. The counterfactual is that training data must always be paid for. There must be a license to secure it. So one of the real challenges here is I think it's worth looking at this ecosystem of what's happening with the big technology companies in AI and copyright right now. So this like crazy looking chart is actually super helpful if you take a minute and look across it. This is put out by a website called ChatGPT is Eating the World, which is probably the most comprehensive tracker of AI copyright lawsuits right now. Um, and you'll see a couple of things here. The big one that I want to point out is just how big the companies are that are litigating this. And OpenAI and Microsoft have bucket loads of money. Meta does too, Google does too, Anthropic does too. These are really, really well capitalized companies that are out litigating and fighting about the right to exercise fair use with copyrighted works. Um, and so, in that context, this legal backdrop, right now there's 40 plus lawsuits, mostly focused on whether it's fair use to use works without permission. Um, and there are some really helpful precedents. The Authors Guild versus Google case is really helpful for this. I mentioned that case already. The parallel case with Hadi Trust is also helpful. In fact, that court even talked about the text data mining applications. Both of them had text data mining researchers submit briefs, so the courts were very well aware of these applications. But these lawsuits are not like easy answers to the fair use question. They're easily going to run into the multi-million dollars, and they're going to take a long time. The Google Books lawsuit took 10 years to get resolved. Some of you might remember the Georgia State case. That took 10 years. These things take a very, very long time to litigate, and you have to have a certain level of capitalization to really fight through these lawsuits. Um, and so we've got a lot of drama around this right now. This is a very heated environment. You probably have all heard about the stuff happening with the Copyright Office, which has been tied, whether correctly or not, together with the office's release of a report taking a position on fair use and AI training. So this is a very fraught issue right now. Um, and my point in raising that aspect of what's going on with all this litigation is to say fair use is great. Uh, Fair use can be very expensive to jump in with both feet and litigate in court and really rely on in the way that these companies have. And so I am a huge supporter of academics relying on fair use and using it for their work for text data mining, for AI purposes. Um, but the reality is that right now, what's happening is these companies are relying on that right, and they're going to go off on their merry way and do this stuff. And those of us who don't have as much money, who don't have the ability to go out and wage a copyright battle in court for decades, uh, might be a little more risk averse. And for those who are more risk averse, and we've seen this already, what is happening is they are turning to legally safe content. Um, and that is really unfortunate if the legally safe content is very, very limited. There's a law professor at Georgetown Law who has uh, a paper that talks about training data that is legally limited but safe as BLFD, biased but low friction data. And her point in this article is that there's lots of data out there that you can get under permissive open access terms. But unless that data set gets bigger, it's going to be very, very biased in a number of different ways. For instance, public domain material is primarily really old stuff. And if you look at who is writing really old books um, in the early 19th century, it's not really representative of who's writing books today. Um, and also, if you look at even content like Wikipedia, she points out, Wikipedia is not entirely unbiased. In that, if you look at the authorship, you've got way more men writing Wikipedia articles than women, and that may influence some of the tone and the structure and really important facets of what the text is. And similarly in sciences, right now the situation is that you've got a lot of people at well-funded institutions who are able to publish open access, but not necessarily everyone, and so that may exclude some open access articles from this data. So. So Ross makes a point in the comment that all data is biased, and this is true. Uh, but we know that there are characteristics of certain data sets that are open that push harder in certain directions than others. You can correct for some of these things, but if you have no data to correct against, you run into real issues. And so that's, I think, part of the impetus of trying to open up more data to address this bias issue. It's not a magic solution, but uh, not and it's not going to fix it entirely. But it certainly helps to give you some options. Um, so the other thing that I think is really important here is this is not just some like shiny new product. It's being used a lot in research applications, and it has really profound impacts for what questions we can imagine asking and how we can answer these things. Um, and so what power do authors and universities have here? Um, I have some thoughts on what we should not do. I think hiding behind paywalls and exclusive licensing deals is probably not going to prevent use of your work for training. And what's going to happen in that scenario is publishers who have obtained copyright in your work will sell it off to whoever they can make money off of. Um, And that will limit the use of your work to basically only companies that have a lot of money that can pay. So this is not good for a few reasons, one of which is it prevents a lot of academic use. It prevents a lot of uses for users who are risk averse and don't want to exercise their fair use rights. Um, and it also prevents more competition and startups to enter that space who might do new and innovative things. Um, and so I actually think that the best thing that you can do, if even if you have concerns about AI companies and what's happening in that space right now, is to actually embrace open access licensing and give legal certainty to downstream reusers. I think that what this does is it opens up the or levels the playing field in a way. It doesn't completely level the playing field. AI development is expensive even without copyright. If you have to go buy 100 A100 processors, like you've got to have a certain amount of money. So there are other bottlenecks, but we can at least help minimize this one bottleneck. The other thing that we can do is make sure that open access copies are preserved and discoverable independent of publishers. There's that saying that possession is 9/10 of the law. Who actually holds the files can be really, really important. Even if it's an open access, a article licensed under open access terms, if it can't be as effectively scraped and ingested, then it effectively can't be used for these purposes. And so that access issue is really important. I think institutional repositories may be taking on enhanced importance given what we see happening with at the federal level. I've heard I can't remember which research group it is, but a German research group has now mirrored PubMed Central for concerns that, it may be compromised. And so I think we just need to be really careful about where copies are preserved and made discoverable. And one last thing, not all publishing is going to happen under open access terms. And so one other way to help address this is to support authors in navigating publishing contracts to preserve rights where open access just isn't possible. A lot of publishers just aren't set up for it, especially book publishing contracts. I've mostly been talking about articles, but um, a lot of university presses really aren't in a place where they are ready to jump in with both feet, but there are ways to preserve in those publishing contracts rights to allow for these kind of downstream fair uses. Um, a couple other things. Protecting researcher rights under fair use is really important. And so I mentioned those contract terms before in licenses for materials that libraries subscribe to for access, and that's something to be really vigilant about. I mentioned Rachel Sandberg at UC Berkeley. She has a fantastic model license for this. And so I would really encourage you, if you're in that part of the e-resource world, to check out what she's got available. Um, uh, I think working with researchers to document their support in formal channels is really important as well. And by that I mean I'll get the model license up in a bit. I think that helping researchers have a voice is really important. Getting like what we've seen with open access policies at Harvard and all of the other universities that have had faculty adopted open access policies, they really help the university speak on their behalf and kind of step into that negotiating position deficit that many authors find them in. So that concludes. And thank you for, I went a whole hour, but I was told I have an hour and a half, so I don't feel too bad about that. And I am happy to now have like more of a conversation about this. And I saw that there was a pretty active chat. I gleaned bits and pieces from it, but not all of it. So maybe we could start with the chat or the Q&A. Will you tell me?
So yeah, first, thank you, Dave. That was really, really useful and thoughtful. A lot of good resources in the chat as well. I'll suggest we start with the Q&A there and then dig into the chat as well, because there was some good stuff. And I'm interested in Molly's question here in particular about sort of power in numbers. that if fair use is understood by a risk-averse person as like that's only for rich people, that's only for people who can at least defend, if not win a lawsuit. I wonder what opportunities you see for us as a community to come together and the braver folks to step forward and everybody to sort of take hands and do something as a group.
Um, yeah, so we've seen this happen before, and particularly in the academic context, one of the curious things that is mostly good, I think, is the academic community doesn't get sued a whole lot uh, for copyright infringement. I think most people realize that there's not a lot of money to be had there. Um, and and you're just not gonna, if you don't want to look like a jerk, you don't go around suing a bunch of people doing research projects. um, so what this means is that there are actually quite a few places where fair use is incredibly important for academic work, but there isn't a whole lot of judicial guidance. And so what we've seen develop is these sets of like best practices on how to engage with fair use. And increasingly, I think that this is one of these issues that could really use that kind of focus of a community of practice around artificial intelligence in the academic and nonprofit context, saying, here are the kinds of things that we do and how they fit together with fair use. And I think those statements have a lot of value in helping the community kind of talk to itself and come out of its shell. I've been involved in one of those projects to develop a fair use best practices document. And I think one of the most valuable parts of it was just getting people to say on the record, here's what I'm doing and why I think it's okay. Um, and that surfacing of information helped a lot of other people along to say, oh yeah, I would like to do that too. And that seems reasonable, but I wasn't sure.
Thanks, Dave. That's super helpful. I've dropped a link to the codes of best practice that are sort of US centric in chat, and there are some good EU versions and Canadian versions that I'm going
Yes.
to try to keep adding into chat as you are talking. So, and thank you, Catherine, for adding this as well. The other question that's in the Q&A section is from Terry, and it asks about NIH-funded research. Faculty are requesting clear guidance regarding whether they'll be safe uploading the AAM to be made available in PMC immediately upon publication if the journal imposes an embargo period. So putting a little, more in the weeds, I wonder if you can speak to this question. I see a couple of +1s in there, so it sounds like a popular question.
Yeah. So whether you will be safe, uh, the safe part is a hard question of like safe from whom. So I think and I guess let me go back. The What happens when you sign an agreement with the NIH is they get this federal purpose license that applies to the work that you create immediately upon publication. And so nothing that you sign later, no agreement with a publisher, no agreement with anybody else can take those rights away from the NIH. So they already have that license. And so with respect to copyright infringement, I don't think that you would have any legitimate copyright infringement case if you were to take that article and put it on the on PubMed Central. NIH has the right to do it. It's already established, so I think that that's pretty clear. Clearly, you would not be in trouble with NIH if you did this because you'd be complying with your grant obligations, so you're safe from them. And I don't know that NIH really cares that much about, what other agreements you sign downstream as long as they can still do the thing that they want. So this leaves the publisher. Are you safe from your publisher? And I think that's probably what Terry's asking is like, is your publisher going to come after you? Right now, we don't have a really clear sense of what they're going to do. I actually have this is a timely question for me because I have a FAQ document that I'm going to post a little later this week addressing this very question. And it seems to me like there are three scenarios for how this could play out. One is your publisher could come back to you and say, yeah, sorry, you got to pay a fee for that. You can't do this. You're in breach of your contract, and you got to pay us. And uh, we've seen publishers roll out these like non-article processing charges. So ACS has this article development fee that they came up with. Um, and IEEE has something called a repository license fee. And so some of them could come back to you and say, you've got to pay. in order to do this. And they do have some leverage. They could like blacklist you, for example, and say if you don't pay, you're never publishing with us again. Um, I don't know that they would do that because that doesn't look so great to go after authors and be that aggressive. Another thing, theoretically, they could also sue you. I don't think that the publishers, I don't think they could sue you for copyright infringement, or at least not successfully. Maybe they could sue you for breach of contract. But that's actually not a great proposition for most publishers because in a breach of contract suit, you would have to prove damages. And I don't know that a publisher could effectively prove damages in that case. So those are the scenarios that I can think of. Really, this depends on how aggressive the publishers really want to be. I tend to think that they will be reluctant to go after authors directly. Um, they may be more willing to go after institutions that are facilitating deposit. Um, but even then, I think that if you'll let me digress a little bit, I think that a lot of these publisher policy pages where you're, submitting your article and you're presented with a click-through agreement, most publishers know that authors are not reading those things closely. They're not going through the 1,500 word explanation of what you can do with the 6 different versions of your article. Um, and it's a very confusing environment. And so, I think there's actually a case to be made here that publishers are potentially inducing authors to sign things that they know are in conflict with pre-existing agreements. And so, if they would go after universities for this, institutions for this, I think the universities have a leg to stand on to come back and say, well, you're inducing our authors and interfering with existing contracts, and that's a legit legal claim. So it's a dicey situation, but we're gonna have to wait and see how this works out.
Excellent, thank you. And Nora plus ones you to note that the NIH policy is focused on the accepted version. So there's these sort of questions about asserting ownership in different versions as well.
Yes.
And Kathy asks to follow up whether librarians who do third-party submissions, are they protected under FPL as well?
Yeah, this is a really good question. So, the only party who's actually protected under the federal purpose license is the holder of that license, which is the federal government. So it doesn't really provide a shield to the author or to the university or to employees of the university, like librarians who might be facilitating these submissions. That said, in everywhere that I can think of, if a librarian is acting as an employee of a university at the direction of the university and uploading something to a federal repository, that person would have a very, very strong claim that it's the university who would be would have to defend any sort of activity like that, and not the individual librarian.
Great point. Yuan Lee asks further, we've struck a rich vein here. Are all federal agencies automatically entitled to use the FPL, or must they explicitly claim it in some way?
So actually, if you look at the public access policies that the agencies have rolled out, um, several of them don't even mention the federal purpose license. They just say this is our public access policy and this is what we're doing. Um, and there's no reason that they have to identify the federal purpose license specifically. But it is true that it applies across the board. So the federal purpose license is part of the Office of Management and Budget uniform guidance that it applies across the board for grants across government. And the whole point of this uniform guidance is uniformity, right? We don't want to have like crazy different terms across grants from one agency to another, and that's why it exists. And so it exists. It's there. It's been in place for like 50 years. I think not a lot of people know that. It's not like this is some new invention of a license for the federal government. This has been in place since the 1970s. And so all agencies are entitled to exercise those licenses.
Excellent, thank you. So changing gears a little, Ben had this question in chat and has brought it into Q&A as well. Thank you, Ben. And the question is whether, they mention a specific politician, but whether a funder, especially the federal government, could decide that certain journals are unreliable or corrupt in some sense, and then use the grant process to dictate where awardees or grantees can publish.
Ooh. Um, that would be quite a situation. So this is less of a copyright issue and more of a First Amendment issue, about how much power the government has to dictate your speech when it's giving you money? And this is a really fraught question, and there are lots of live questions about this in the courts right now. Uh, the answer, I think, historically has been that the government can't coerce you into speaking. And we've had a number of cases like this over the years where the government has dangled like Medicaid money over hospitals and said, here's our money, but you're only allowed to say certain things or do certain things. Um, and, knowing that if they withhold that money, the hospital goes bankrupt and the whole system kind of collapses. And in those cases, the courts have been very careful about saying you can put some strings on and terms and conditions on what you're funding, but you can't so coerce an entity that they would basically cease to exist. But this is a really a challenging issue, and I think highlights some of the the crisis in federal funding right now is like if this administration wants to push its thumb really hard on what can happen with research outputs, but it could have very disruptive effects. And so I'm not ruling out that like such a thing would pass muster. I think you'd have a really good First Amendment case that would be filed. And in fact, there is in a kind of different environment, there's a case right now that's pending in the courts about some researchers who I believe had written about it was a series of papers about gender that were disfavored by the administration and were taken off of a NIH website. I think it was NIH or some HHS agency taken down, and they said you can't just remove our stuff because of the content of the speech. Um, and that's usually the touchstone for a First Amendment suit, is you want to look at, is the government making decisions based not on kind of neutral factors, but on the content of what your speech is.
There's probably an analogy to the question about libraries receiving funding and whether they have to use filters or not. Is this a content neutral quality decision, or is this a politically motivated decision in some sense?
Right.
And John notes in chat as well that that's what's happening in Texas, dealing with curricula and research outputs at state universities as well.
Yep.
So thank you for that one. Melissa has a question, really appreciates the session, very relevant to scholars. How do you see the role of undergraduates in the activity of research in this struggle? When we're considering our collection development activities as librarians serving primarily undergraduate students, it's often an opaque process and we're caught between a rock and a hard place.
So I didn't talk a whole lot about undergrads, but they're a really interesting category of people when it comes to university IP policies and what they create and what the university can say or do about it. They're, of course, not employees of the university. And so you don't have this like work for a hire overlay. Um, and sometimes undergrads really do contribute a lot of intellectual content. I mean, undergraduate research journals are have some really amazing stuff in it. Um, and so you do have live questions about control. So for the most part, university policies have been either silent on undergraduate works, copyright ownership of undergraduate works, or they have they've explicitly done basically what they've done with faculty and said, maybe we have some rights, we're not sure, but the undergrads own those things. So they've been generally pretty permissive. Where I see more of the issue with undergrads is going back to that set of license terms that I had, restricting people's ability to use works that they obtain usually through the library in conjunction with AI tools. It's hard enough to explain to, a graduate student who's doing a structured research project about what all those rules are, but trying to police and control undergrads taking articles off of Science Direct and asking ChatGPT to summarize it seems to me like a battle you will never win. And so I think there's like an education component there of helping them understand a little bit about copyright law, but I'd be really hesitant to try to um, really police that kind of activity. So I hope that answers it. There are like 12 different versions of how to answer a question about undergrads engaging with AI and open access, but I hope that was helpful.
Awesome. I'm seeing some applause and hearts, so it sounds like great job there. I'm interested in this question. as to, I think there's a what is there and what should there be component to this. Should there be a distinct legal definition of scholarly works? And does copyright law treat academic, nonfiction, and fiction works differently? So there's the what is the law today, and would there be benefit in carving out these are scholarly works and those are treated differently, however we define that term?
Yeah, so there isn't under US law, there is no special definition of scholarly works. Of course, university IP policies can define them by contract, and they do that all the time. In other jurisdictions, you actually do have a separate legal category that applies special rules to things like scholarly works. I'm thinking about some European countries that have secondary publishing rights, for example. Um, and whether they should be treated differently is a very interesting question. I think that one of the big challenges with US copyright law is that, and copyright law internationally, is it's just expanded so rapidly and kind of treats everything, if not the same, kind of similarly. So the same copyright protection that a major motion picture studio gets in a movie that it invested $100 million in, is the same copyright that I get for the notes that I took on this notepad that I might throw in the trash later. Um, and, that just doesn't make a whole lot of sense to a lot of people. And I think this is true in other contexts, right? Like the same copyright that a novel author gets over their work, maybe the same rights that a Reddit user gets when they comment on a post. And so there is this big disconnect. That's actually one of the innovations of Creative Commons licenses to me is it helps solve for that kind of one size fits all system. And it says, we're going to leverage these rights that were just kind of foisted upon us and turn them around and reuse them in a way that's going to achieve the thing that we want. So one, for instance, is US law provides no attribution right at all. And when you talk with academic authors, like the most important thing is I want you to cite me and I want you to attribute my work. And so the Creative Commons licenses do that very cleverly by kind of turning copyright on its head and saying, okay, you gave me something that I didn't really ask for and is kind of disruptive to what I'm doing, but let me reorient that and use it to achieve something that I do want.
Super helpful. Thank you very much. So we have one more question here that we'll answer. If folks have other questions, feel free to add them. I'm conscious we're coming out to the half hour, and I'm super impressed that so many people have hung out with us. You must be doing a great job, Dave. So the question here is, why can the US government claim rights on the accepted manuscript? That version of the article seems to have had publisher facilitated input.
Yeah, so this is a good question about who owns what rights in what version. So of course, when the author submits the manuscript, the submitted version is just like totally the author's version. There's no input by anybody else. Um, and so clearly the author can relicense, have rights that are given away in that. So this question is basically about the accepted manuscript incorporating uh, other materials from the publisher. And I want to note, like, they're from the publisher, sort of. They're peer reviewers who the publisher rounded up mostly for free, almost always for free, who submitted comments. But nevertheless, like, kind of filtered through the publisher. So I think there are two versions, two ways to look at this. One is in no case that I'm aware of has a publisher said, I've never seen a peer review thing that comes back to me that says, you must accept this edition and it must be included in your article. And so ultimately, it's still the author making a choice about what they put in and how they respond and how they express that idea that the peer reviewer communicated to them. And so copyright cares about expression and less about ideas. And so ultimately, in those situations, it's the author's expression that ultimately ends up in that accepted manuscript. Um, so that I think mostly answers why the author is really the one who holds those rights and is able, therefore, through that chain of title, to grant those rights to the government. Um, but even if you don't believe that, and you're like, yeah, but the publisher still had meaningful input in what that expression looks like, and they had some role here, the most that would do is it would mean that the publisher has some sort of joint authorship claim. And even if the publisher is a joint author, That still means that the other joint author, in this case, the researcher, is still allowed to grant a license to that work to authorize all sorts of reuses without having to go check with their other co-joint author. And so it would still be a valid license. The only distinction in there would be that then traditionally in those joint authorship cases, if one author authorizes a license to a downstream user, they are subject to an accounting to their co-author. So, if I wrote a book with Will and then I signed some sort of licensing agreement with it and I made $1 million off of it, I would owe him half of that, or whatever proportional amount, we might have to fight about it in court. But proportional amount. So in this case, it's an interesting question because there's no money changing hands for the actual manuscript itself.
Awesome. Thank you. And here's one last question. This is a great note to end on, and then maybe we'll hand it back to Nick to thank everybody. If you could change one thing about US copyright, what would it be? Here's your magic wand. Go to.
Just one thing.
Let's start with one.
All right, one thing. So I think the biggest problem with US copyright law is how automatic it is. And so it used to be that you actually had to do something in order to obtain copyright. And so we had all sorts of creative things that were produced that no one ever bothered to copyright because they didn't want that protection and it was kind of burdensome to go through the process. So you had to register and you had to go renew your rights. And then in the 1980s and 1990s, we got rid of that process. And we just said everything automatically gets copyright, and it lasts for like centuries. And if someone violates it, you get to sue them for potentially hundreds of thousands of dollars. And that seems to me like not a good approach. The other thing that I would change is the being able to sue people really easily for hundreds of thousands of dollars. Copyright has this other thing that kind of magically happens where it says, if you register your work and then someone sues you, you are able to just kind of elect from this statute damages up to $150,000 per work infringed. And you don't actually have to prove that you were harmed. You get to just like pick. And that idea that, we're able to just kind of rack up damages without actually proving harm, I think is really disruptive to the system and is a really unique thing about US law. You don't have the system in other places. And the U.S. copyright system is, I think, plagued by us generally being a more litigious society than other places. But something that sure doesn't help is that the financial upside of winning a lawsuit is basically winning the lottery. And so that incentivizes a lot of really unreasonable copyright claims. So I could go on. I have like a endless list of things to change, but thank you for letting me volunteer that.
Yes, and one friendly offer as well as Carla has led a contingent of digital first sale votes that has picked up a lot of popular steam in the chat as well.
That would make a huge difference too.
Yes. Excellent. Well, we are at half past. I can hang for a few more minutes, but I do want to be respectful of Dave's time and of everybody else's time as well. So Nick, do you want to send folks off? And then if we want to hang around and chat a little more after, we can?